Good afternoon, everyone. I'm Susan Bryson. I'm chair of the philosophy department, and it's my great honor and privilege and pleasure to introduce today's speaker and to welcome you to the 9th annual Dorsett Lecture. The Dorsett Fellowship was established in 2001 when the Frederick Gardner Cottrell Foundation, in conjunction with Research Corporation Technologies, made a significant donation in honor of Bert Dorsett, class of 1953. To establish an endowed fund on the occasion of his entire retirement. Oh, we need it to be a bit louder? Okay, I'll pull it closer and I'll move it up. All right. The purpose of the Dorsett Fellowship is to honor the exemplary business career of Bert Dorsett by bringing practitioners of ethics or scholars of ethics, or both, to the Dartmouth campus. Sadly, Bert recently passed away, but his legacy lives on in this program. And we're delighted that his daughter, Debbie, is able to join us this afternoon. Thank you for coming. Past Dorsett Fellows include the author Tracy Kidder, presidential historian Michael Beschloss, author Barbara Ehrenreich, Columbia University President Lee Bollinger, former editor of the New England Journal of Medicine, Marcia Angel, animal rights activist Temple Grandin, and entrepreneur Tom Chappell. It's our hope that through these campus visits, students, faculty, and community members will share in Bert's passion for doing the right thing by witnessing examples and leaders from a variety of fields. To that end, we were absolutely delighted that Anita Allen was able to serve as the 2012 Dorsett Fellow. And I want to thank in particular Anya Donovan, director of the Ethics Institute, for doing all of the organizational work and for enticing Anita to come to this campus because she's extremely busy, a very much wanted speaker. Professor Allen is an expert on privacy law, bioethics, and contemporary values, and is recognized for her scholarship about legal philosophy, women's rights, and race relations. In 2010, she was appointed by President Obama to the Presidential Commission for the Study of Bioethical Issues. Anita Allen is the Henry R. Silverman Professor of Law and Professor of Philosophy at the University of Pennsylvania Law School. And as I said, she is a much sought-after speaker, and so we are simply delighted that she was able to be here at Dartmouth as a 2012 Dorsett Fellow. I want to add, as someone in philosophy and in law, that our both professions, philosophy, law, are very indebted to the work that Anita Allen has done, and not only on scholarly issues, publishing academic books and scholarly articles, but she is that rare, I find, scholar who is a public intellectual, who writes about things that really matter, and who publishes books that are accessible to people who aren't necessarily professional philosophers. I recommend her work to you very highly, in particular a book that she published several years ago called The New Ethics, a guided tour of the 21st century moral landscape. If you haven't seen that, I really recommend picking that up. It's a wonderful, wonderful book, and I can't think of a better tour guide for our trip along the moral landscape, which she often shows us is more hazardous than we might have realized, but always proves to be the wisest and most compassionate guide. So we're delighted to have Professor Allen here today to give a talk on privacy in an era of revelation and social media. Goodbye to health privacy. Please join me in welcoming Professor Anita Allen.
Perfect, thank you.
I just covered up your talk.
Thank you.
There you go.
Thank you, Susan, and thanks everyone who contributed to my being here. I'm really happy to be here. I must say that I spend an awful lot of time, and have for many years, worrying about the fate of privacy. Am I the only one who's worried about what's happening with privacy in our culture, in our society? We live in an era of increasing personal revelation. We live at a historical moment characterized by the wide availability of multiple modes of communication, easily and frequently accessed, capable of rapidly disclosing vast quantities of information about sensitive matters to many people. And in this era of revelation, which is dominated by all of our wonderful portable electronics and social media and reality television and shock radio, many of us are losing, I believe many of us are losing our sense of privacy, losing our taste for privacy, and also losing our willingness to respect privacy, our own privacy as well as that of other people. And the question that I have to pose is this set of losses a bad thing? Is it a bad thing that we may be losing our sense for privacy or taste and our willingness to respect it? Is that a bad thing? And although I love my Facebook and my Twitter and my cell phone as much as anybody my age could, I will argue that it's mostly a bad thing that we're losing all this privacy. So I want to begin with a bunch of examples which don't have anything to do with healthcare, but they're examples which to me illustrate the problematic ethical ethos of our revelatory era. And I mean, the examples show that in every segment of society there's a real possibility that we're sort of losing it. I mean, it seems like nobody cares about privacy, not artists, not government officials, not school officials, not roommates. Nobody seems to care. All right, so a kind of a gloomy message, but let's see how this goes. So this is the world we live in. First example.
Some people can't quite hear, so
okay,
it's
all right.
not really as
All right.
directed.
So am I speaking here or here or both? All right, okay. All right, we'll use this mic. So first example. Joyce Maynard. When Joyce Maynard was only 18 years old, she had an intimate affair with the famed writer J.D. Salinger, the author of Catcher in the Rye. Again, she was only 18, he was 53. Right. So 6 years ago, 2006, Maynard decided that she wanted to sell the 14 unpublished love letters that the reclusive Salinger had written to her in the 1970s. She said she needed the money to send her children to college. Now, it's not self-evident to me that what Maynard did was ethical. It was legal, right, to sell the letters. They were her property. But query, is it ethical to sell and therefore take the risk of exposing to the public intimate love letters by someone whom you know to be deeply devoted to their own privacy? Second example, do Congress people care about privacy? All right, so remember this guy. Former Congressman Anthony Weiner was a Democratic member of the U.S. House of Representatives elected by the people of New York. He sent sexually suggestive images of himself as attachments to his Twitter messages to women he barely knew. When knowledge of his sexting conduct became public in June of last year, he was forced to resign from office under pressure of his fellow Democrats. Okay, so members of Congress, artists. What about school officials? Well, in the fall of 2009, a scandal exploded in my neighborhood, the affluent Philadelphia suburb of Lower Merion, where all the public high school students are issued Apple laptop computers for free. So the school, though, by remotely and secretly activating spyware, they collected tens of thousands of screenshots and webcam images of students inside and outside of the school. Isn't this, I mean, it's shocking. I mean, it's just shocking. When the practice came to light, one student named Blake Robbins filed a lawsuit claiming privacy intrusions prohibited by state and federal law. A school district official confirmed the district did not disclose the fact of this theft track remote activation feature to students or teachers or parents because it involved computer security. In October of 2010, the school board voted unanimously to settle the lawsuit and ended up having to pay over $600,000 to the student and his lawyers for this violation. It was really kind of a shocking disregard for privacy. Another example, one that you've been hearing about a lot recently, 2010, freshman Tyler Clemente, the young man with the violin, asked his university roommate at Rutgers, Darun Ravi, to let him have the room for the night for a date. Well, Ravi consented, but concealed a webcam in the dorm room, webcasting Clemente's same-sex intimacies all over the internet. Well, when Tyler Clemente learned what had happened to him, the distraught gay youth bid farewell to his friends online and then went and jumped off of the George Washington Bridge. Now, Ravi's thoughtless advantage-taking was unethical, I would argue, and as moral luck would have it, it also had a devastating outcome, compounding the sense of its wrongfulness. Now, I personally was not surprised when a couple of weeks ago, Ravi was convicted of bias intimidation and criminal invasion of privacy. But Ravi was very surprised, remember? I mean, he had turned down a plea bargain under which he would have gotten community service. He was so sure he was going to win, but he lost, and now he faces 30 years in jail and the possibility of being deported to India. My final example in this first non-healthcare part of the talk is WikiLeaks, right? So according to WikiLeaks' website, they are a group that publishes material of ethical, political, and historical significance while keeping the identity of our sources anonymous, thus providing a universal way for the revealing of suppressed and censored injustices. Well, in 2010, an anonymous source who turned out to be a young man named Bradley Manning, an Army intelligence analyst, this anonymous source leaked hundreds of thousands of secret and confidential diplomatic missives to WikiLeaks. Well, the sensitive documents were published by WikiLeaks and then republished in major newspapers, mainstream media, social media alike. And a lot of people were appalled by this occurrence, but strikingly, many were not appalled because they felt that there was no legitimate expectation of privacy, confidentiality, or security in diplomatic missives, or because they believed the social good of disclosure here far outweighed any embarrassment to diplomats or to nations. So what's the social good at issue? Well, some critics say consider the Arab Spring, right, the freedom movement. This was sometimes tied to WikiLeaks disclosure. But still, some people believe that the disclosure of the WikiLeaks documents was unethical, and many professors of foreign relations, I think, still are refusing to teach the WikiLeaks documents because they believe that they are ethically tainted. Okay, so these examples show, again, from many directions, how it seems as though privacy is no longer particularly valued. It's at risk here because people don't seem to think it's that important. So in this age of revelation, sensitive information will come to light, whether it ought to or not. Our love lives may come to light. Our political strategies may come to light. Everything may come to light, for better or for worse. Our genomes may come to light. So a special concern, I believe, is the fate of health privacy, of medical privacy and confidentiality in the age of revelation. Everyone who participates in the delivery of health care has an obligation of confidentiality. They're bound by norms of confidentiality, as many of you know. Doctors, nurses, dentists, psychotherapists, technicians who are directly involved in patient care, they must abide by confidentiality rules, as must hospitals, data processors, and insurance companies. These norms of confidentiality also apply to health research, not just to clinical care or to processing of insurance matters, but to health research, and they apply to people, for example, ethicists who are involved in IRBs or hospital ethics committees. In the field of bioethics, a field which I'm involved in both as a member of the Bioethics Commission, but also because it's just an interest of mine, in my field, confidentiality looms very, very large as an ethical standard. The ethical codes of the medical professionals, like nursing and doctors and nurses, have always dictated confidentiality. And not only that, but we have federal laws that dictate confidentiality and privacy. So we all know HIPAA, the Health Insurance Portability and Accountability Act, 1996. Well, HIPAA created a whole set of privacy and data security rules that were developed by the Department of Health and Human Services that went into effect in 2001. And these rules provide a national framework for protecting health information. HIPAA requires, for example, patient consent in advance of some disclosures of health information. Now, as you know, HIPAA has its limitations. One of them is that you can't sue under HIPAA. If your doctor discloses your private information, what you can do is you can file a complaint with the Department of Health and Human Services, and they may or may not act on it. Other limitations in some people's minds are that HIPAA does not prevent health data from being disclosed without your consent, for example, for research purposes, law enforcement, and so forth, patient processing of data for insurance. So information that that's created in the context of healthcare is widely available to all kinds of people. There's no sort of absolute right to health privacy. But HIPAA isn't the only legal protection for health information. We have many state laws that pertain to, for example, HIV/AIDS. Genetic privacy, it has protection under some state laws, and of course there's also now a federal statute nicknamed GINA, for Genetic Information Non-Discrimination Act, which limits disclosure and the use of genetic data for purposes of employment and insurance. So, lots of law protecting privacy in the healthcare field, lots of ethics protecting privacy in the healthcare field. Now, despite all this ethics and law, the fate of health privacy in the era of revelation is, I think, quite uncertain, because many well-meaning people who work in the health services industry still do not grasp the nature of their responsibility. I think the mic is going in and out a little bit. Yeah. Where's the tech guy? All right, okay. So let me give you an example of how sometimes having both law and ethics in place doesn't do the trick. Here's an example. So, real case. In 2001, a hospital called Alenia hired a woman named Misty Young as a phlebotomist, the person who is trained in drawing blood. And in 2003, Misty and all the other health employees at her hospital were required to attend a training session regarding HIPAA. Misty signed the hospital's confidentiality policy and code of conduct. Attendees at the training session received a motto to remember: what you see here and what you hear here remains here. What happens in Las Vegas remains in Las Vegas. What happens at Alenia Hospital remains at Alenia Hospital, right? So she was trained and trained and signed papers saying, I understand my duties of confidentiality. All right. So one day, Misty learned from handling blood test reports for the hospital that a woman named Suzanne was pregnant. Several days later, Misty and several of her friends visited a local tavern. Sarah, the sister of the pregnant woman, was a waitress there and happened to be one of Misty's best friends. So Misty said, well, how's Suzanne doing? And her sister says, well, what do you mean, how's she doing? You know, being pregnant and all. Right? Well, Sarah was shocked. Why? Because her sister, her twin sister, hadn't told her that she was or ever had been pregnant. When this breach of confidentiality got back to Suzanne, she sued the hospital and Misty for breach of confidentiality, invasions of privacy. So, despite all the training rules, all the training, all the ethical training, all the legal training, Misty blabbed, right? Now why? Okay, so here's my theory. I mean, my theory is that well, you kind of get that you're professionally bound by all these rules. You kind of think on a practical level, though, that there are all these exceptions to the rules, and the rules don't especially apply to friendships and families. That if you're kind of talking to your friends or your family or people who about their families, you're really not doing anything wrong, and you shouldn't get in trouble. But the fact of the matter is that those kinds of disclosures are indeed ethically and legally problematic, as Misty discovered the hard way. She lost her job. The hospital got sued. So why does it matter? What are the reasons why it matters that people may disclose your health information? Why is privacy, medical privacy, so important in the first place? Why are the rules important in the first place? A lot of you know this list that I'm about to give you, by heart, and it won't be nothing new to you, but some of you may not be aware of the standard reasons why health privacy is important. I believe in these reasons. I think they're real reasons. So one reason why healthcare privacy is so important, confidentiality and privacy is so important, is that we think individuals will be more inclined to seek medical attention if they believe they can do so on a confidential basis. Some people see seeking health care as a kind of a weakness or a loss of control, and that feeling is compounded if what they're about to tell the doctor or the nurse or the practitioner is going to be disclosed publicly. If your health matter may involve an STD or illegal drugs, you don't want everybody in the world to know about that. You may not want people to know that you're pregnant. You may not want people to know that you have bowel incontinence. It's embarrassing. It's particularly so. It could be even humiliating. So probably the main reason why we have health privacy is that we want people to go to the doctor, and they won't go if they think it's going to be embarrassing to them or lead to some social shame or material losses. I think a lot of people also are just reluctant to speak about certain matters, disfiguring growths, depression, loss of memory, delusional thoughts. You don't want the whole world to know that these kinds of things are happening. You can barely stand to tell the doctor. You hate to have those things be public, be posted on the web or on Facebook. And so another reason why we like medical privacy is because we think that it ultimately reduces healthcare costs. If people will go to the doctor quickly, it will mean that we won't have all these sort of ER visits. We won't have so many people getting seriously ill, untreated illnesses, late-stage cancers. Those are expensive to treat. Cheaper if we get people in quickly, get them treated, get them cured, and save those costs, those healthcare costs. Those are all utilitarian kinds of reasons for being in favor of health privacy. I believe in them, but it's not just utilitarian kinds of reasons that I think kind of back up the case for health privacy. You could frame the argument for health privacy in more sort of dignitarian terms, referring to individual rights, to dignity, to respect for persons, these sort of Kantian, deontic, or even Eritaic notions. I think that we should show care and concern for others that are fitting for them as morally important persons. And if we keep information about their health and their health needs private, we show respect for them in a very important way. And there's another argument which could be made, which is sort of a contractarian, a legalistic contractarian argument. People pay for health care, They're buying your confidentiality. So since they've bought it, you owe it to them. So if you blab, you're breaching your contract, and it's morally wrong and legally wrong as well. But I don't particularly like that argument. But I think it's out there in the literature. Some people do think that the fact that we are paying for health care generates kind of an ownership over the data and a kind of entitlement to have that information kept secret if we want it that way. And so I believe that some combination of these utilitarian and non-utilitarian reasons are very, very strong, and they're strong enough to force us to want to keep honoring medical privacy, even as our culture becomes more open about healthcare matters. And without a doubt, we are more open about healthcare matters. And I think that's not a bad thing in many respects. So, breast cancer is losing its stigma. Addiction is losing its stigma. STDs have lost some of their stigma. And we can now appreciate it when, for example, celebrities decide to share their healthcare problems with the general public. We like people like Michael Douglas or Michael J. Fox, or Pat Summitt or Juliana Ramshack or Demi Moore or Lindsay Lohan or Muhammad Ali or Magic Johnson or Glenn Campbell, on a long list, celebrities whose willingness to speak openly and publicly about their healthcare and healthcare problems, it increases awareness, makes ordinary people more willing to own up to their health problems. It also, I think, increases research dollars. I think the more glamour and celebrity there is around diseases, the more people are willing to give money to support research for those diseases. So it's a good thing. But I don't think that the fact that many of us are now open about our healthcare problems, we talk about them at work, celebrities talk about them on TV, I don't think that means that we have to say, okay, well now, healthcare privacy is no longer important. It's no longer a valuable thing. It is, even though some of us choose, for a variety of reasons, to share on a selective basis. Okay, I mean, there is this, I know that a few people in here come out of the computer science, information technology sort of world, and I think especially among technologists, there's a tendency, I call it a woeful tendency, to make sweeping statements about the death of privacy. It's gone, but I mean, that sense that it's gone and it was maybe a good thing that it's gone, it has to be looked at, side by side with the fact that there is this philosophical tradition, right, which says that privacy is a very important and useful thing. There's a pretty large literature on privacy that goes back to the early 70s in which philosophers have tried to articulate, what is it about privacy that makes it a good thing? Not just health privacy, but all privacy. And they have linked privacy with many positive values or positive conditions like human dignity and self-expression and a good reputation and repose and creativity and intellectual life, intimacy and civility and toleration for others. And the list goes on to include things like autonomy and individualism. And so privacy has this sort of philosophical tradition which says it's a good thing, and I think that needs to be remembered as we listen to the technologists saying to us, it's all about free speech and about expression and about on the net, and we don't have to worry about privacy. It's dead. So I'm not ready yet to give up on that philosophical set of literatures and theories that suggest that there is something there that we want to protect and keep emphasizing. So in my opinion, medical privacy is not a dead value and has not outlived its usefulness in a well-ordered society. Okay, so there's a lot of fancy, cutting-edge privacy issues that bioethicists are today talking about, and I want to just mention a couple of those, but I want to focus more on the more sort of routine challenges of health privacy that are out there in our society. So some of the more cutting edge issues, have to do with genetic testing and biobanking of tissues and who has access to those tissues and whole genome sequencing. Our commission is looking at that issue as I speak. Neuroimaging, ethics, and who has access to the brain and the mind and the self, and issues about who has a right to know and a duty to tell. So there are all these like cutting edge issues out there that we could debate and talk about, and it's really quite exciting and exhilarating that as we move forward with science and technology, that we are in fact still, at least in my field, thinking about the role that privacy has in connection with new technologies and new techniques and new medical procedures and new medical research. But I think more relevant actually to the ordinary hospital employee or doctor or patient is some of these kinds of things. Well, first of all, we have HIPAA in place, but HIPAA compliance has been surprisingly difficult for some healthcare companies. Recently, the Department of Health and Human Services has gotten tough because for a while, if you violate HIPAA, you get a little slap on the hand, So your patient records are accidentally left in a truck for all to see. Okay, don't do that anymore. That's bad, Correct that practice. But now the DHS is getting really, really tough and imposing fines. A good example, last year, the Department of Health and Human Services fined the Signet healthcare system of Prince George's County, Maryland, $4.3 million. For what? What did they do? Well, HIPAA gives you a right to see your medical records, to access your medical records. And if your doctor or your hospital won't give them to you, they're violating HIPAA. Well, this hospital system for some reason, refused to give 41 patients their medical records. And guess what? They got fined $4.3 million. They also got fined because when the department there's a division of the Department of Health and Human Services called the Office of Civil Rights, and they go after the alleged offenders. Well, when they went after Signet to investigate the claims that they weren't giving out their patient records, Signet went very defensive, wouldn't respond to the subpoenas, wouldn't cooperate, and that's also why they got fined $4.3 million. So HIPAA compliance is a problem, and I think that fortunately it's beginning to be seriously enforced by the department. That's a great thing, and I think it's about time, and I'm really proud of what's happening with DHHS today. Another kind of more routine threat to privacy has to do with data breaches. So a data breach is basically any time data which you're holding is either intentionally or accidentally lost. So someone hacks into your system, or your employee loses their laptop and all the data gets lost. That's a data breach. And hospitals have been just sort of remarkably plagued by these data breaches, all kinds of them. I got a letter a few months ago from my children's pediatrician saying, dear parents, unfortunately we've lost your children's medical records. They were in a file. They're not really, we can't find them, but they're kind of not really, but we don't know exactly where that filing cabinet went, but don't worry, they're not really lost. It was a very strange kind of a letter sort of saying that they kind of lost track of the children's records, but they weren't willing to own up to their being totally lost. But this happens a lot. Johns Hopkins Hospital a couple years ago, they misplaced a whole truckload of patient data that was being moved off-site for document destruction. And then here's a pretty shocking one. So last year, Stanford University Hospital reported that the medical records of 20,000 emergency room patients were posted on the web. Their names, their diagnostic codes, and how this happened. Well, it appears that one of their vendors, multi-specialty collection services, it looks like maybe one of their employees was trying to get some help with some homework or something, and need to make a bar graph, and so he used his patient data and put it in like a graph form and posted it on the web, so it was there for months, right? So this is the data breach, right? So sometimes sort of because of a little bit of cluelessness, it gets data breaches occur, but usually in the healthcare context, it's not a hacking. It's not like someone hacking into, TJ Maxx to get the credit card data. It's like it just gets lost. The files get lost. The old, floppy disk you're trying to destroy get lost, or someone, again, accidentally uploads something onto the internet. But that's a real threat to patient privacy. Other kinds of problems, besides slips of the tongue of hospital employees and these sort of non-compliance with the laws and these inadvertent data breaches. Well, in the age of revelation, whole businesses are growing up around our medical data, and the norm in the United States seems to be that we're gonna kind of default in the direction of letting people use our data. That's the default rule. It's available unless. So I was very disturbed last year by the Supreme Court ruling in the Searle versus IMS case. So in this case, the Supreme Court heard a challenge to Vermont's prescription confidentiality laws, which were enacted in 2007. And this was a statute which restricted the non-consensual sale, disclosure, and use of pharmacy records that reveal prescribing practices of identified physicians. Well, the purpose of this law was to safeguard the integrity of the doctor-patient relationship, protect medical privacy and confidentiality, and to deter harassment by aggressive drug vendors. Well, the data miners who profit from preparing reports for drug companies based on pharmacy records, along with the manufacturers of brand-name pharmaceuticals who market their products to physicians, they challenged the Vermont statute as a constraint on commercial free speech. They won. The data miners argued that free speech for businesses includes the right to gather and convey our physicians' prescribing data. The Supreme Court rejected the state lawmakers' claims and struck down the statute 6-3 in opinion by Justice Kennedy, who wrote that speech in aid of pharmaceutical marketing is a form of expression protected by the free speech clause of the First Amendment. Surprising. To me, surprising. A couple more examples quickly. A lot of hospital systems and patients are using cloud computing. I confess, I myself, upload things like my images, my mammograms to my cloud computing, like to Dropbox. I confess, I do. Hospitals are using third-party vendors to store data off-site, and it's a very efficient, effective, and way to preserve and protect data. But what happens to it when it's in the cloud? Who has access to it? A lot of times we don't even know exactly what the parameters are of a third party accessing and using our data. This is the real issue that I think many healthcare privacy experts are worried about today. And finally, there's an increasing tendency to put court records online, bankruptcy filing, criminal history records, other court documents, and sometimes those records contain health information, right? Disclose that maybe you're bankrupt because you had to spend $40,000 on a surgery. Well, your health data can end up being posted online through some legal mechanism that you weren't even thinking of as a risk to you. So that needs to be taken care of as well. We have to learn to redact, and we are doing this increasingly, redact legal records to make sure that sensitive health information isn't disclosed. Now let me step back and say something about the lure of all this disclosure. Disclosure, 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 disclosure. Disclosure, even when it concerns your health. What's bad about it? Is anything wrong with it? What's bad about it? Should we even worry about it? Well, sometimes when I'm trying to explain to people why I think privacy, and including healthcare privacy, is a value, and why we should kind of restrain ourselves from disclosure, I go back 200 years and 2,000 years to find the language to explain, the value of privacy. So one of my favorite 200-year-old examples is, John Adams' diary. In his diary, he argued that privacy is an instrumental good, and it's a duty of self-care. We have a duty to ourselves to protect our privacy. As the slide says, worldly wisdom dictates that we protect ourselves from damage, danger, and confusion by generally keeping our sentiments, actions, desires, and resolutions to ourselves. Revelations to our friends and our enemies alike can lead to loss, disgrace, and mortification. And I think even today we can see that there's a value to us, a practical, prudential value to being a little bit reserved, because we don't know what other people might do with our data that might be harmful to us. Okay, so that's one way to think about it. There's another way, a less utilitarian, prudential way that may resonate with some people. So go back 2,000 years. I love this passage. You don't have to be religious or Christian to like this, but there's a passage in the Gospel of Matthew that presents a certain kind of privacy as an intrinsic good of righteousness or piety. Maybe you've read this passage, but it's about giving to charity or almsgiving, about praying, and about fasting. And in these passages, basically, it says something to the effect that when you're doing these things, giving money, praying, or fasting, don't do it like the hypocrites do, all like obvious and loud, and do it privately. Disclose, conceal the fact that you're doing it even, because if you do it all loud and obviously, you've gotten your reward. But if you do it quietly, privately, discreetly, then here it's put in the terms of your Father who is secret will see you and reward you. But I think the point of this passage, sort of secularizing it a little bit, is that there's a kind of an intrinsic value of righteousness and piety in giving to the poor without expecting people to congratulate you, praying without people that guy is such a good prayer, or fasting without saying, oh, what a sacrifice she's making, doing those things. There's an intrinsic value to being reserved in these sorts of activities. But not everybody kind of resonates with these sorts of examples, the John Adams example or the Gospel of Matthew example. But they do, I think, have a certain continuing value in our culture. Law can do a lot to protect health privacy, right? But law can't do everything. And unfortunately, in my view, ethics isn't doing enough. And I'll give you two very concrete recent examples. I use a lot of examples from law cases because I'm a lawyer. Okay, but here's a lawsuit that I think shows how maybe law and ethics are not working well and not working well together. So here's an example. Here's an example called the case of a fresh placenta. There was a nursing student named Doyle Burns at Johnson County Community College, and in 2010 she was expelled from school, expelled from her nursing program for what college administrators viewed as an inappropriate bit of conduct on Facebook. She apologized for her conduct and felt that expulsion was not really justified. that she shouldn't have been kicked out of school. So she sued, and the Kansas federal district judge that heard her case sided with her. And so in January of last year, Judge Eric Melgren issued a preliminary injunction ordering not only that Burns be reinstated, but that she be allowed to make up missed assignments and exams. Well, what did she do that was so horrible that caused her to get kicked out of school in the first place? Well, in 2010 November, she was taking a clinical course on obstetrics and gynecology at the Olaf Medical Center in Olaf, Kansas. And as part of the course, she was asked to examine fresh placenta from recently delivered pregnancies. Well, she and 3 other students, Christy North, Jamie Vandy Brake, and Danielle Thompson, they wanted to photograph themselves examining the placenta to post it on Facebook. So they obtained a kind of permission from their supervisor, Amber Delphia, to photograph themselves. And so the teacher said, you can photograph yourself with this placenta. Though the teacher said, okay, you can do this, but make sure that you don't put anything in the picture that might identify who the placenta came from, the pregnant woman or the newborn baby. No identifying marks. Like, okay. So it wasn't until after the class that the supervisor asked the students, well, what do you intend to do with these photographs? And they said, we're going to post them on Facebook. And she said, okay, oh, you girl. Okay, she didn't say okay. She said, oh, you girls, like that. Oh, you girls, just like that. Right. So the girls felt they had permission to post the pictures on Facebook, which they did. But when it came to the attention of the college that the photographs of the nursing students with their placentas were on Facebook, the girls were expelled. But the judge enjoined the expulsion for several reasons. First, he said the conduct in question may have been inappropriate or offensive to the college, nursing college, but did not violate any clear policy or disciplinary rule. Second, since photographs are meant to be shared, granting permission to photograph was, in effect, granting permission to share face-to-face, on Facebook, or anywhere, presumably. Moreover, by only saying, oh, you girls, as was alleged, the instructor missed an opportunity to object on school policy, on legal or ethical grounds. The judge did not buy the argument made by the other side, the school, that somebody might be able to figure out the patient from whom the placenta was taken. I mean, like, suppose, for example, that on this day, only 2 people had babies, right? Well, then that kind of this is like Mrs. Jones's placenta, Mrs. Smith. So it could conceivably happen in a smaller hospital that someone might figure out that, oh my God, that's my placenta, right? But the court thought, unlikely. So that was not a reason to side with the school. But I mean, this to me is not a case in which the placenta is likely to be identified or re-identified. So it's not really about that. But it does seem to me, and we can talk about this in Q&A, it does seem to me that something of ethical significance has happened here, that the girls, the women in question, the nursing students, would have been ethically better had they not chosen to photograph themselves with the placentas and post it on Facebook. And the kind of reserve that I think they might have displayed is maybe it's a little bit like that passage in Matthew, kind of a pious reserve, kind of a tasteful pious reserve instead of sort of showing off would have been maybe a better way to respond to their clinical training. But here's another example, which I think you would be more likely to agree with me that the people involved were unethical as well as illegal in their invasion of privacy. So in this case, this is a case from 2009, a woman named Candace Yath, and here she is, Candace Yath. I actually, she's on Facebook, so I went and got her, there she is. She's also on Yasny and MySpace, so the list of things, the list of Yasny sort of concepts, unfortunately revealed the past about her, which I'm sure she would like to forget. And I'll tell you the story, you'll understand why. But she cannot escape her past in part because of the world of social media, Facebook and Yasny. She put herself on Facebook, but the Yasny is involuntary. So just happened. Okay, so this woman, Candace Yaff, was a patient at the Fairview Clinic in Minnesota. She revealed to physicians at the clinic that she was having an extramarital affair and that she thought she might have an STD. So she was examined, and indeed she did test positive for STD. Now, it just so happened that one of Candace's husband's relatives, a woman named Navy Tech, saw Candace at the clinic and was curious about why she was there. So Tech worked at the clinic as a medical assistant with access to electronic records of patient health information. So she decided to take a little peeky-see, right, to take a look at Candace's health records. And boy, was she shocked when she discovered that her husband's, her family member's wife was an adulteress with an STD. So Tech could not keep a secret, so she called another relative, said, guess what I just found out, Candace, blah, 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 blah. And then this second relative called the sister of the husband of Candace and said, your sister-in-law is having an affair and she has an STD. And then the sister-in-law called her brother and said, your wife, is, all right. So this violation of HIPAA and state confidentiality laws led to the patient losing her marriage because her husband divorced her over this, right? Okay. But that's not the worst of it. Well, maybe it is the worst of it, but something else happened, which is quite awful. So a Facebook page was erected that was captioned "Rotten Candy," and it basically said that this woman, Candace, was an adulteress, a nasty, dirty girl with an STD, and she's also addicted to plastic surgery. I don't know where that came from, but they also just said she was addicted to plastic surgery. So this very, it's sort of embarrassing MySpace page, and they used her actual picture, by the way, as well. So someone did this to her. Someone in her own family probably did this to her. She never could figure out exactly who did it, but during the litigation, which ensued, because Candace, of course, she sued the hospital, she sued her, all these people who were, who blabbed and told and accessed her medical. She sued everybody. Well, she in litigation discovered that a computer having the internet protocol address assigned to a business where one of her husband's family members worked was the source was where the MySpace page was put up from. So clearly, someone tied to her family was responsible for this. In her lawsuit, she had a couple of problems. One of the problems she had is that the defendant said, putting up a MySpace page, that's not publicizing. That's just putting up we don't even know if anybody ever saw it before it was taken down. Fortunately, I believe the court that heard this case argued that putting up a page on MySpace or Facebook, for that matter, it's just like publishing something in the newspaper or broadcasting it on the radio. It's a publication. So for purposes of invasion of privacy, you can claim that a publication that is highly offensive has in fact occurred. That was the good news. The bad news was that because she couldn't prove who actually put up the MySpace page, a lot of the defendants were dismissed from the case, and she wasn't able to pursue that part of the claim. But she was able to pursue her claim against the hospital and her husband's relative who did the first invasion of her medical privacy. Okay, so I'm going to conclude by a couple more thoughts. A lot of philosophers recently have talked about privacy, but there aren't that many philosophers going back in time who had specific things to say about privacy. So we philosophers are kind of left, to sort of look at in between the lines at people like Locke and Rousseau to figure out, how would these great political philosophers think about modern privacy issues? And, Locke emphasized that we're sort of driven into society by our natures, and that we are pretty social beings. We do have individual rights, so I think from a Lockean perspective, we're on good ground in trying to articulate a rationale for protecting privacy. And similarly with Rousseau, he was much more inclined to see society as sort of a second best. We are, by nature solitary creatures, and we have to come into society for protection and so forth. But we do have a strong interest, I think he would have said, in our solitude and in our aloneness. So we don't have a lot of again, a philosophical canon to back up the kinds of things I'm trying to argue for, but we do, I think, have some relevant authority. Finally, we have a need in our society today to be able to forget things that about ourselves that were not so favorable, and the EU is currently in the process of rethinking its privacy laws, and strikingly, the proposal from the EU that came out last week was to create a kind of a right to forget, to require data holders to destroy data about us that is sort of old and perhaps no longer so relevant. So in conclusion, I ask the question, so what are the kinds of things that we should hide? What kinds of things should we hide? This is kind of a weird version of this slide. It's kind of the colors. This is a cover of my latest book. It's called Unpopular Privacy. I don't know what happened to the colors there. It's weird. Yeah, I mean, it's like it should be green and red. It kind of looks like one of those airport scanners. So it looks like an image of like me going through an airport scanner. But it's about the privacy that we're not perhaps affectionate about, this book. And in the book, I do conclude by saying that there are certain things that we should try to hide and keep quiet about. And I do include medical confidentialities among those things. But in general, I think we should hide what's necessary to hide in order to protect our common dignity and our separate virtues. We should hide what's necessary to keep ourselves safe from harm. We should hide what our roles and responsibilities and professions dictate that we hide as matters of efficacy, beneficence, or contract. And we should hide, notwithstanding all of technology's attractions, what relationships, good relationships and reputations now and in our distant and uncertain futures renders it prudent to hide. So telling us exactly what to hide and why is the work of a comprehensive ethic of privacy in the era of revelation. Thank you. So I would love your questions and comments. Yes, ma'am.
One of the first questions off the top of my head, thank you for a great talk, was just has it been legally established that social network sites can be considered published? And if so, does that mean have there been slander or libel cases?
Good. So yes, there is now some judicial authority that if you post information on a Facebook or a MySpace, we'll talk about MySpace is sort of dead, so Facebook, that it is published for purposes of defamation, libel, slander, and invasion of privacy. Now, there may be a few courts who disagree with that proposition, but I think there's now increasing authority that it would count as a problem. And there have been successful libel and slander claims brought against people who've posted information on the internet. Yeah, maybe some of you have heard of the AutoAdmit case. This is a case, I think I have a slide about AutoAdmit. But AutoAdmit is a website very popular with law students, and it calls itself the most prestigious law school discussion board in the world. And a couple of, someone identifying himself as AK-47 published photographs and very, very insulting and libelous statements about two Yale law students, accusing one woman of things that didn't even make sense, like enjoying being kicked in the stomach while pregnant and having sex with her father. I mean, things of that kind of crazy, nature. So the women who were slandered, they brought a lawsuit in federal court, and the court struggled with the question of the free speech rights of the anonymous poster versus the rights of the women to be protected from defamation. And the court found that you can be held liable for defamation on the internet. So yes, we are finding that the courts are saying, just because it's the internet, it doesn't mean you have free reign to invade privacy or to defame people. Yes.
I have a quick question about the kind of mystery Susan case that you were talking
Yes.
about. I was wondering what you think about the fact that in that situation, the hospital is held responsible to some degree for what happened, even though it sounds like they did absolutely everything that needed to be done with regards to training Misty on HIPAA policies, and yet it's them that got sued. And yet
Yeah. I mean, if you look at what the hospital did, you could argue that the hospital was not negligent. They trained their employees. They got them to sign statements that they understood the training. They were HIPAA compliant otherwise. So yeah, but unfortunately, when it comes to personal injury law, employers are pretty much always liable for the negligence of their employees. There's this technical doctrine called respondeat superior. So the boss is responsible, has to respond to, be responsible for the negligent wrongdoing of the employees. So they can be held liable for this kind of a thing. Now employers will try to not be liable by saying we did everything possible, but again, they're liable even if they're not negligent for the negligence of their employees. So it can't escape that, unfortunately, under American tort principles. I mean, you kind of wish it were different, right? But if you think about it from the point of view of the victim, from the victim's point of view, they're not going to be able to recover against, a low-paid employee. But the company, right, the hospital system or the hospital they can afford to pay. And I think a lot of this doctrinal development in this area is based on the notion that we care so much about the victim, we want to give the victim access to a deep pocket. So we hold the employer responsible. Yes. Yes, sir.
It seems the idea of privacy has changed a lot from generation to generation or decade to decade. Where do you see the idea of privacy going in, say, 20 years? Will people have a concept that there is such a thing?
Great question. And you're absolutely right about the concept kind of changing. I recently completed a paper which is going to be published in the Fordham Law Review. And this paper looks at the very, very, very first American court, and it happened to be the Supreme Court of Georgia, that found that there was indeed a right to privacy. Because, believe it or not, until the early 1900s, no court had squarely reached that conclusion. And what basis, what sort of normative value foundation did the court give in defending its legal conclusion there's a right to privacy? Well, it turned to natural law and argued that sort of our human natures make us inclined to want to separate ourselves sometimes from society and sometimes go into society. And it's our free choice as free beings that we should have a choice about whether or not we have privacy or not. And the judge went on, though, to say something quite remarkable, which is that a person whose privacy has been violated is like a slave to a merciless master. I mean, that's how important this early 19th century court thought that privacy was. It's like slavery to be without it. The case in question involved a man who woke up one morning and found that his photograph was included in an advertisement for insurance in the local newspaper. He had never bought insurance. He never, posed for this picture for this purpose. But a photographer with whom he had dealings just gave or sold the picture to the New England Life Insurance Company. They thought he looked pretty good, healthy, robust guy. They just put the picture in the advertisement. And so that case led to a lawsuit in which the court said, even though up till this point the courts have not recognized the right to privacy, there clearly is a right to privacy, and I'm going to allow this person to recover based on it. Go forward and his lawsuit to recover based on this theory. So at one time we thought about privacy that way, or some of us did. Fast forward to 2012. I don't think a lot of people think of privacy as a natural right, or that privacy is like, losing your privacy is like slavery. I mean, come on. I mean, it may be bad to have your picture on Facebook and you're called rotten candy, but you're not like a slave. All right. So we don't think about privacy that way anymore. We think about it as kind of we have a right to data protection. We have a right to choose whether our images are published, but we don't have this it's not sort of so profound as all of that. Now, in Europe, however, there is a whole kind of human rights discourse around privacy and data protection. They do think of things like whether you have, banking privacy or or medical privacy as a human rights issue. We don't have a strong human rights discourse about privacy in the U.S. today, and we certainly have lost, I think, contact with our kind of natural law origins. So you ask the future, what's going to happen? See, I think that privacy is being trivialized, and that people are now thinking of an invasion of privacy. It's sort of like a minor inconvenience, you know. It's like a minor thing, and it can be a minor thing. It can be a minor thing. If someone, I don't know, if you're sitting in a corner of a school cafeteria reading a book and someone comes up and asks you a question, they're in some sense invading your privacy. It's a minor thing. But it's a not so minor if someone takes your medical record and you're trying to run for school board and they decide to publish your medical record all over this local newspaper. So it's not always trivial, but I do think there's a kind of a tendency today to think that probably all that privacy talk is about something that really isn't that important. Yes.
Thank you. It's wonderful. I've been teaching a course on free speech and confidentiality rights. The last time I taught it a few years ago, I was just stunned that students, in general, this generation, my students' generation, weren't so worried about invading privacy. And several actually said, the only reason you're afraid of having private information with you is because we have these messed up puritanical views about sex and things are stigmatized, and if we could get rid of all this shame around private issues and sex, it would be fine. And what I found difficult, I don't know whether it's a generational difference, and I wonder what your view is about this. And I think there's a very close connection between privacy and intimacy, and that our intimate relationships with our partners, our very close relationships with friends, are based in part on what we choose to share with them. And if all of this information is made public, then those relationships.
Because I like to pretend that I'm young and hip, but I'm not. I hate to. But there is a generational difference, and I have teenagers, and I know that they just don't see privacy the same way I see it. I mean, my daughter thinks that when you have a relationship, you find out about it on Facebook because the person that you have a crush on will change their relationship status. Then you know that you have a boyfriend, right? Or if you're going to get dressed, you have to post a picture of yourself wearing the outfit on Facebook to see whether or not people like it. And so living in this very, very public way, sort of seeking approval, being accountable to your peers, that is for I think a lot of people who are under 20, that is the way to live. It's a way of sharing, which is a good thing. They think sharing is a good thing. Being part of a social network is a good thing. And I don't think that's entirely bad, but I really worry about the ability of people who are living with so much accountability, how they develop their own sense of self and their own independent character when they're constantly being judged by other people and are altering their behavior based on very quick assessments of other people of whether or not their conduct is to be approved or not. So I think there is a difference, and it's one that I worry about. One common thing said by people between 20 and 30 is that we care about privacy, but we define it differently. So we do regard our social network on Facebook as a private sphere. And when our parents or our employers intrude, they're violating our privacy, right? So there is a sense of privacy, but it's a much different and I think actually problematic one, because now when the employer, does access your Facebook page and sees those pictures of you, drinking beer and wearing a bikini or less than a bikini, and decides not to hire you, you think they violated my privacy. But it's not private in the sense that I think you and I would think it was. It's not. Our intimate lives are being exposed, therefore they're no longer intimate. So there's a difference. Yes, definitely. Yes.
So I work at the hospital, and I often take complaints from patients. That's one of my roles at the hospital.
Lucky you.
And, I enjoy it.
Good.
And but one of the things is I really want to hear more about who defines the privacy. So this is kind of not just the very young feeling this way, but one of the very common things that happens to me is we have a patient portal. Our patient portal has some privacy privacy standards built into it, right? So you have to have your own email address, right? So
Right.
your medical record is your email address. Well, I can't tell you how many times in a week I get calls by a husband or a wife, and they're not young, they're elderly, and they share their email, and they've been sharing it for 5 years, and they want to see each other's medical record.
Right,
Who are we
To tell them they
hide
can't.
from them?
Yeah, yeah. I mean, and in the way the case I described of the Candace Yaf case, Rotten Candy case, it was a family defining privacy differently. They felt like within their family, everyone had a right to know that one of their members had an affair and that was wronging, the husband. That was a family matter. And you're right. Some people define themselves as units. And they think that, well, the family, the husband and the wife, or the partners in a relationship should be able to should share and do share, and that it's artificial to impose these sort of HIPAA type confidentiality rules on people. So you're absolutely right, and we have to make a choice, I guess, as to whether or not we're going to define privacy rights exclusively in individualistic terms, or whether we're going to admit that there are some units, perhaps families or couples, which are equally valid for defining privacy rights. Now, one solution would be to say, well, people can always choose to give their partner access, or their husband access, or their mother access. We don't want to, though, assume that they want to, right? But again, some people find it offensive, as you're describing, that they can't automatically share in their common lives. Whether it's gay couples or old married couples or whatever. It's absolutely just true. Yeah.
Just because we're in a public forum and I want to be completely open about it, there is a way. We've come up with a mechanism in which you can be a personal representative and you can go through some actions to share with your husband or wife. Just unless you were going to call me tomorrow.
So you can't just say, you can't say, I give blanket permission for husband or wife. You have to create this relationship of what did you call it? A personal representative. So we're mutual personal representatives, so therefore we can share information. It's a clever little way to get around the law, but it works. It works. Yeah.
The personal representative is in HIPAA. It is the law.
Yeah.
It is the legal way we establish sharing, and I work in that same hospital. Not in the department that gets the complaints, but in the department that manages the consequences of those. And we have lots of examples of folks where sharing was assumed, and then something's changed in a relationship, a divorce or something else, and there is no basis for us to explain why someone has access to someone else's record unless we have a designated personal representative that can be revoked at a future time.
Yes, and so there are mechanisms recognized by HIPAA that allow for people to gain access. And when I say get around law, I don't mean get around the law in the sense of it's not legal through HIPAA, but what I meant was that it's a device that gets around the law of individuals' privacy rights. But it's very interesting. Okay, thank you. Yes.
Aren't we talking about two things here?
Yeah.
Might it make a difference, as in this circumstance, of the person who wanted the record on email to be offered an alternative to receive it on paper? The difference is huge between having something on the internet, which the email is, and having it on one piece of paper which goes to the person who wants the information.
Right. I think, though, that that these days there's a strong sense. I know my hospital now provides a patient portal, and one can go online and you can make appointments, you can break appointments, you can request referrals, you can request drug prescriptions, you can see the results of your medical tests. And many people find that it's much more convenient to have all this data available online than to have it be sent in the mail, right? Now, it could be done that way, sent in the mail, but having it all there electronically available is greatly convenient for many people. But the underlying your question, I think, is an anxiety about aren't we, though, then opening up all these questions about potential hacking, disclosure, and so forth? Answer, yes, we are. But I think for a lot of us, the benefits outweigh the risk, and therefore we go forward with the technology.
The signal that the Q&A formal session has ended. Perhaps Professor Allen will stay for a little while longer to answer questions individually, but let's all thank her.
Thank you. Thank you.